When they're thinking about leasing, landowners should be very careful to think in the long term. Leases can certainly outlast many generations. It's not unusual when we're working with landowners to run into leases that were signed in the 1800s and are still valid. Landowners need to be very careful in their leases to make sure that their environmental rights are protected. Because these leases are likely to last for generations, landowners should be careful to make sure that their leases will protect their land. Having good protections for crops and timber and surface rights, including water testing and use of water on the property, could prove to be very, very important for landowners in the future. That's an important thing for landowners to have in their leases today. Landowners often have problems with leasing because their mineral rights have been severed from the surface rights. What that means is that oftentimes in a prior generation or a prior transaction, someone has retained the mineral rights or the rights to lease for oil and gas, for example, but sold the surface separately. Those two things, the oil and gas rights and the surface, can be sold and traded through different transactions, and the mineral rights don't always run with the land. And just because the landowner doesn't own the mineral rights at the outset or doesn't think that they have clear title doesn't mean that they can't get it. There are statutory processes in Ohio which provide a legal mechanism for landowners to go through to retain those mineral rights and have those put back with their surface property. By following that statutory process very diligently, the landowner can get those mineral rights reinstated or reconnected with their surface rights. That then would make them eligible to lease again, and they could take advantage of what's going on with the shale boom today in Ohio. Another issue that we often see with landowners relates to old leases. Many landowners, particularly here in Ohio, find that at some point in the past there had been a lease for their property, or there had been a well drilled, for example. Just because there's a well on your property, or there has been a lease at some point in the past, or even a lease today, doesn't mean that the landowner is not eligible for leasing currently. There are a number of different things we can look at to see if the current lease is still valid and enforceable. And there are some statutory steps and legal things that can be done to forfeit that lease or to clean up the chain of title. By following the statutory process, it is possible, and we've been successful in doing this in the past, for the landowner to clear the chain of title and still be able to lease the deep well rights and take advantage of some of the things that are happening in Ohio today with the oil and gas boom. Bricker and Eckler has worked with a lot of landowners to clear up title and has found that it's often beneficial to get that process started early. Following these statutory processes can be time-consuming, and it's easier to do that before you get a lease from an oil and gas company than after the oil and gas company finds a problem.